Welcome back to the course. This is protecting the legal rights of artists and designers. And I am Jonathan Politi, and we are working our way through the materials covering the legal system and dispute resolution. And in this segment, we will be covering alternative dispute resolution. And so jumping into that, typically when people think about the law, they focus on courts and lawsuits and attorneys. Those aren't the only aspects of the law, though. They matter. They do potentially affect businesses, and they are worth understanding what they're worth. We've been going over court proceedings and process. There are alternatives to using the court process to resolve disputes between parties. When people can't agree and they can't work it out themselves, there are other options which we call alternative dispute resolution. So alternative dispute resolution, or ADR as it's known, are alternative methods for solving issues between parties. Some you may have heard of. More than likely, all of you have agreed to use some form of ADR at some point in your lives. Those are methods for resolving disagreements without having to resort to court proceedings and carrying the matter all the way through the trial process. The advantages to using ADR have been touted as being less expensive than going to court, that they are faster than court proceedings because the processes are streamlined, and that the rules are more informal and less restrictive than what would be found in court proceedings. Information that isn't normally permitted as evidence in trial may be allowed in alternative procedures. About 30 years ago, ADR was touted as the best thing since sliced bread. It would revolutionize how businesses would take care of disputes, a win-win solution for everyone involved. But that isn't always the case. Many times, the agreement to enter into ADR, should there be a problem, is built into contracts that people sign, and they don't realize the rights that they are relinquishing by entering into that agreement. Almost all contracts with large businesses, you will likely find an arbitration clause or a mediation clause stating that the parties to that contract are willing to forego the legal right to go to court and instead will submit to arbitration. That can be in an old-timey, pen-to-paper, sign-on-the-dotted-line contract. That can be on a modern click-through terms of service agreement online. An arbitration clause or a mediation clause or ADR clause limits the rights of parties, especially when they are giving up the right to file a lawsuit collectively and to join forces when it wouldn't make economic sense to file smaller lawsuits individually. People who are similarly situated can band together to confront a large business that may have violated their rights. It's giving up a right to go to court in exchange for the ability to settle dispute elsewhere. Depending, that can be good or sometimes not so good. Again, you're giving up a right to court in exchange for something else. There are certain types of alternative dispute resolution that have been established. People using them can set their expectations that they are reliable, predictable, and trustworthy so far as the processes are concerned. Now, I've had students ask me over the years about a term that they've heard called kangaroo court. That's not really a thing. It's not a form of ADR. It's really a reference to a proceeding that is not trustworthy. It doesn't follow the principles or processes of law, and it's meant as an insult or to complain about a process that may not seem fair. But it's not really a court, and it's not alternative dispute resolution. Now, I've also had students ask me over the years about Judge Judy and the other quote-unquote courts that are on television. Judge Judy is not really a court of law. She is a retired judge and she resolves disputes on syndicated television. It's not a court of law. It's made to look like a court of law, but it's not a court of law. And she may have a robe, and she calls herself a judge, and she's actually a retired judge, but it's not a court. So it may look like a duck and quack like a duck, but it's actually a platypus. So it's not a court, but Judge Judy is actually a form of alternative dispute resolution. All right. There are different forms of ADR, different forms and different formats. They have different procedures, different processes, different advantages and disadvantages. Some you may agree to ahead of time, such as in a contract. Some you may agree to in the midst of trying to accomplish something as a way to work past an impasse, such as in negotiations. The results or outcomes from ADR can be binding or non-binding. Binding meaning the parties would have to abide by whatever the outcome is, and that it can be enforced if one of the parties decides not to follow it. And non-binding meaning that the parties are not bound by the outcome and do not have to follow it if they don't wish to. We can briefly take a look at these different forms of alternative dispute resolution. Arbitration and mediation are two forms that most people have heard of. Mini trials and referees, ombudsmen, and summary jury trials, those exist also. Tribunals from industry groups and even mock trials are some of the options for ADR. Let's cover some brief explanations for these. Arbitration is one that people agree to often. Arbitration is a voluntary process where a third party or parties come to resolve the dispute. They're known as arbiters or arbitrators, typically 1 to 3 experts in a field of practice, and they're called to review the issues and weigh the evidence that the parties present to them. The proceedings are structured and follow the rules that are established by the Uniform Arbitration Act or the Federal Arbitration Act. Again, you can find arbitration clauses in many contracts that you agree to. Remember, the outcome can be binding or non-binding, depending on what was agreed to at the beginning. And again, I want to reinforce with this, arbiters or arbitrators, they are the ones who decide. They make the decision, and then their ruling either gets followed if it's binding, or if it's non-binding, then the parties can choose to follow it or not. Mediation is another form of alternative dispute resolution, the process by which disputes are settled by a neutral third person called a mediator to help them work through the issues and suggest solutions. Mediators can help find common ground and places for agreement, but the mediator does not dictate the solution. The mediator does not decide. The parties are helped to settle and agree to a resolution. Usually, the nice thing about mediation is that everyone gets their chance to be heard and to participate, and they're more than likely to invest themselves in following through on the agreement because they've been part of the decision process rather than just being given an edict. And again, remember that the outcome can be binding or non-binding depending on what was agreed to at the beginning. All right, that takes us to summary jury trials. Summary jury trials are another option. A summary jury trial is a pretend trial that is used to test the waters. It's held in front of a jury, and it's meant to duplicate or mimic a real trial to find out what a jury would decide if the case were in front of a real court of law. These are usually non-binding, so the outcome is more a message to the parties, a measurement of what actual outcomes could be, and it gives information to act on and to perhaps settle a dispute. Mini trials. These are similar to a summary jury trial in that they are a pretend trial conducted in front of a retired judge without a jury with a similar purpose to test the waters and find out how an issue would be decided if it were to be put in front of a judge. Again, the outcome is usually non-binding. And then there's ombudsmen. An ombudsman, that's a process within an institution where an appointed official reviews complaints and offers or suggests methods to resolve a dispute with the hope of resolving issues and satisfying all parties concerned through consensus and agreement. The ombudsman provides the opportunity to be heard, as well as knowledge of process and values. The results are non-binding, and the parties are able to enforce rights in court if they decide not to follow the Ombudsman's suggestions. So, why are we covering this? What is so important about alternative dispute resolution? You should be aware that options other than going to court to resolve problems exist. Be aware that you may have already agreed to some form of alternative dispute resolution. Sometimes they're built into an agreement, such as an arbitration or mediation clause. Be aware of what you sign before you sign it. Look before you leap, because you may be giving up your right to go to court as a way to enforce your rights. And be aware that different processes, requirements to be in different locations, and requirements for what laws and processes will be applicable to resolve the dispute may be different than if you go to court. Be careful. And look before you leap. Again, read before you sign or before you click I agree. And again, ADR is not bad. Just know what you're getting into so you can set your expectations. And in the larger context, you want to be aware of how things work and what your options are. Know how laws are formed. Know how the law was formed and the purposes behind it. If you need to change it, know how. If you need to respond to it, know how. Know where to look for laws that apply for you. What do you want to do to be in compliance with the law and to avoid problems and penalties? Or if it's after the fact, what you've done. Know what processes you will be subject to if there's a breach of the law. Have you violated somebody else's rights? Have your rights been violated? What process applies? Court, agency hearing, ADR, or something else? At the very least, you need to be able to understand the concepts so that you can talk intelligently and be able to know what your options are. Okay, that brings us through these materials. There's going to be a quiz. It's going to cover the materials we've had up until now. It'll be a multiple choice format, and it'll be open book, meaning you can use whatever materials you have access to. Look for this on Moodle. I'll have it posted probably by tomorrow, and then I will give you probably the next week to check in with that. You can review materials, and I'll post a deadline online for that.